All right, good morning. We'll start with the circuit civil docket call.
10351 McCarson versus Humphreys County.
Good morning.
In this case, I was going to get with Mr. Williams and set some discovery deadlines. If we can have one more, we can pass it one more time. Can't resolve it, which I think we may be able to. And I'll get with Mr. Williams and try to set those deadlines in advance of the next review day.
Well, this is just here for status, so any reason, Mr. Williams, that you would have any opposition to that?
Judge, I think October 1st is your next civil motion day.
That sound all right? October 1st?
Yes, sir.
We set it for October 1st.
Thank you, Honor. That's all I have.
10549 Michaela Miller versus John Doe.
Good morning, Your Honor.
Good morning.
Gagliano of the National Bar. That's not a motion for interlocutory appeal. Should be less than 5 minutes.
I'm ready to hear it.
As I said, Your Honor, this is my motion for interlocutory appeal based on a denial of my previously filed motion for summary judgment. The court will recall this is a case where plaintiff reported to the investigating officer that a FedEx truck caused her or hit her vehicle. She then testified in her deposition she was hit by a FedEx truck. I pointed fault at FedEx in my answer as well. To this date, FedEx has still not been added. The UM statute clearly states that a plaintiff cannot recover against their UM carrier if the insured was negligent in failing to determine the identity of the owner or operator of the alleged unknown vehicle. And Your Honor, I cannot think of a more textbook definition of negligence when the plaintiff believes they know the owner. I've alleged fault on the owner, and they don't even have them in the lawsuit or attempt to take any discovery to determine the identity of the driver. The court obviously denied the motion based on a dispute of fact as to the identity of the owner. The order is, unfortunately, Your Honor, devoid of addressing the issue of the negligence or the reasonable effort which is required under the case law and the statute to determine the owner of the or operator of the vehicle. Obviously, it doesn't matter if they don't know the operator if the owner is readily available. And Your Honor, we would just submit to the court that the prongs for allowing an interlocutory appeal are present here. Obviously, if FedEx is the proper party, then my client, my carrier, doesn't have to be involved in litigation. It just seems like a needless waste of time and expense to go all the way through a jury trial on an issue where FedEx should be the proper party here defending the case. And that's essentially the issue, Your Honor. Thank you.
Good morning, Your Honor. Caroline Preston for plaintiff Michaela Miller. Your Honor, the defendant has failed to establish any basis for interlocutory review. They have argued that they will suffer irreparable harm as they have a right to be dismissed from this case if plaintiff is unable to set forth facts supporting their allegation that the driver and or owner of the FedEx vehicle is unknown. Plaintiff, in her response to defendant's motion for summary judgment, showed plenty of facts that the driver is unknown. We do not know anything besides that there was a FedEx name possibly printed on the trailer of the vehicle. However, as most people know, just because the trailer is owned by somebody does not mean that the truck and the driver are employed by FedEx, that the truck is owned by FedEx. Plaintiff has been able to support her allegation that the driver is unknown and that there is a dispute of material fact that should be left up to the jury to hear. Defendant argues that review is necessary to prevent needless, expensive, and protracted litigation. The costs associated with this case are the same as any other civil litigation case. Plaintiff's deposition has already been conducted in this case. Defendant finally argues that there is a need to establish a uniform body of law here, but they have not supported that prong of Rule 9 with any evidence that there is a conflict in Tennessee authority requiring appellate clarification. Defendant has failed to satisfy the 3 prongs of Rule 9 for interlocutory appeal, and we ask that their motion be denied.
You might.
Again, Your Honor, it's irrelevant if we don't know who the actual driver is. And I don't know how familiar the court is with trucking law, but the MS-90 endorsement, Your Honor, is created for these specific situations where if you've got a sub that's uninsured, the insurance just goes up and up and up and up and up and up until there is coverage. So this is, even if this is a subcontractor for FedEx, there's going to be coverage. They're not going to be uninsured or underinsured under the statute. And all we had to do was sue FedEx. That's all we had to do. That's all the plaintiff had to do was name FedEx in their lawsuit. We could have conducted discovery. We could have figured out who the driver was at the very least, or who the owner was at the very least, let alone the driver. But again, the very textbook definition of negligence is to not sue the person that you believe to be the owner or knew to be the owner of the vehicle, Your Honor. In the court of appeal, there's just not a lot of law on the issue of the reasonable effort to determine the owner of the vehicle, Your Honor. So that, again, does fall under one of the prongs as to why this case should go up to the Court of Appeals to address this issue.
Well, Rule 9 does provide for the possibility of an interlocutory appeal, and it provides for the procedure for the trial court in that a party seeking an appeal must file and serve a motion requesting the relief within 30 days from the date of the entry of the order appeal from. When the trial court is of the opinion that an order not appealable as of right is nonetheless appealable, the trial court shall state in writing the specific issue or issues the court has been certifying for appeal and the reasons for its opinion. The trial court statement of reasons shall specify the legal criteria making the order appealable as provided in subsection A of this rule, factors leading the trial court to the opinion that these criteria are satisfied, any other factor. And those factors are the need to prevent irreparable injury, giving consideration of the severity of the potential injury, the probability of its occurrence, probability of any that review upon entry of the final judgment is then effective, the need to prevent needless, expensive, protracted litigation, giving considerations to whether the challenged order would be a basis for reversal upon a final judgment, probability of reversal and whether the interlocutory appeal will result in a net reduction of the duration and expense of the litigation if challenged order is reversed. The need to develop a uniform body of law, which I'm not sure that applies in this case. Clearly, in this particular case, the issue arose as to whether or not the uninsured motorist coverage would apply when the driver of the vehicle was unknown, but that the logo on the outside of the vehicle indicated that it was a FedEx. And making the ruling, this court referred to the fact that while the vehicle itself could have a FedEx logo, the actual driver of the vehicle was at this point unknown, and it could have been any variety of factors which could lead it to not necessarily being an employee of the FedEx company to make them a defendant. In looking at those factors that the rule allows, I don't find that there is a need in this case to grant an interlocutory appeal to prevent irreparable injury, because this is an issue that the jury may very well agree with the defense that there's no proof that the FedEx or people or that the driver was unknown, and therefore it would always be up to the jury to make that determination, and subsequently an appeal following a verdict in favor of the plaintiff may actually resolve the issue as well. The need to prevent needless, expensive, and protracted litigation. This is no different than any other type of personal injury claim, and therefore I don't find that factor would apply either. And thirdly, the need to develop a uniform body of law. There is some argument to be made that the standard for which you determine whether or not what reasonable efforts have been made by the plaintiff to determine it would apply, but this court stands on its order and denies your motion for an interlocutory appeal. Obviously, there's another rule that you can apply to the appellate court without this court's intervention if you wish to do so. All right. That will be the ruling of the court that denies that. If you'll put in my findings in your order, please.
Thank you, Your Honor.
Thank you, Your Honor.
Nice. At least we have 10600 PM minor versus AAC investments. These may be good copies on top.
Zoom link.
Oh, no.
I did. Could be on it. I'm not getting it back. We need more chairs. All right. According to the docket, we have a series of motions, so we'll just start with whoever wants to go first, I guess.
Your Honor, just Joe Griffith using Coleman, your local counsel in the case before we do a lot more proportional damages. But we have Texas law firm Houston, who's pretty much BSA. Defense counsel has no objection. They're admitted to the state bar, and I have an order here for considered for
Where'd you go to law school?
Shout out to the University of Houston.
Very good school. I've done the research to know that's where I went.
We looked into that.
It is.
For some reason, I get the feeling that you and I were not in the same class.
And maybe so, but I mean, we have had some of the same professors.
I don't know. All right, I'll sign the order.
I represent AAC.
Right.
I'll start with the motion, more definite statement. The Honor has a different way he'd like to proceed.
I don't care, however you want to go. You have, we have a motion for a more definite statement, and then we have a number of motions to strike. So those are the things that I showed.
Good morning, Your Honor. My name is Connor Blair. With me at the council's table is John Griffin. We represent the defendant in this case, AAC Investments. We also represent AAC's corporate tenant, Accurate Energetic Systems, AES. For the purposes of the motion, more definite statement of the AAC. Let me begin by saying that John and I and our clients have tremendous sympathy to the plaintiff in this case, as well as for the families of 15 other AES employees who died in AES explosion of October 1st. Let me also say that we have no intention of delaying plaintiff's recovery from those who may be liable. We learned recently that the plaintiff is already receiving workers' compensation benefits from AES. Before the court today are two motions, as we discussed, we're going to be talking from my clients. We're going to be discussing first.
Well, let me interrupt you because I know that issue about his the decedent's status as an employee is one of the main issues you've raised. You just said that he's receiving workers' compensation benefits from whom?
From AES.
Okay.
So we represent AAC, who is the landlord of
Right.
AES. The AES building is exploded in plaintiff's fault. AES building. Your Honor, let me also preface my argument by just noting that this is an important lawsuit. A lot is at stake, and it's likely to be just one, perhaps 16 similar lawsuits arising from this tragedy. It's critical that this court ensure that this case proceeds in an orderly manner and in compliance with the Tennessee rules. And those are the considerations that form the crux of both AAC's motion for more definite statement and subsequently AES's motion to quash. Getting to the motion for more definite statement, Your Honor, the amended complaint is the operative complaint. Plaintiff filed a complaint, didn't serve it, and then a week later filed and subsequently served an amended complaint. So the amended complaint is what we're discussing today. And in the amended complaint, there's one cause of action for negligence, but the negligence theory is, and the supporting facts are simply not sufficient. The amended complaint states that an explosion occurred, and then recounts the myriad ways one could, theoretically or hypothetically, be negligent in the state of Tennessee. And then it concludes that AAC caused the explosion and is therefore liable for negligence, gross negligence, and punitive damages. Just last week, however, for the first time, plaintiff's counsel clarified plaintiff's theory of the case, seeming to abandon its theory that AAC caused the explosion in favor of the premises liability. They made this motion in their briefing in opposition to the AES motion to quash. But the amended complaint, the operative pleading in this motion, remains too vague for AAC to respond to. And it contradicts plaintiff's counsel's briefing and their opposition to the AES motion to quash. Now, this matters because as the amended complaint is currently pled, it seems to suggest that AAC controlled the building 602, which is the building addition, which would make AAC the statutory employer of plaintiff's father. That matters because if that is the case, then this lawsuit belongs in the Court of Workers' Compensation Claims, and this court has subject matter jurisdiction over AAC. Your Honor, as I'm sure you're aware, a statutory employer is one who retains the right to control the work being performed and the workers performing. If the amended complaint alleges, consistent with that definition, that AAC retained the right to control the work being performed in building 602 and the workers performed. The amended complaint is short, but it is replete with allegations tending towards that conclusion. Paragraph 1, for instance, says that AAC owns building 602. Paragraph 6 references building 602 as, quote, defendants AAC's factory. Paragraph 8 alleges that AAC, quote, was in control of and was the owner, operator, and manager of building 602. Your Honor, based on the insufficient allegations, we moved for a more definite statement. In opposition, plaintiff's counsel states that they seem to double down on their theory that AAC controlled building 602. Page 5 states that AAC controlled the building. Page 6 identifies AAC as, quote, the owner, operator, manager, person in control of building 602. Page 9 states similarly that AAC owned, operated, and controlled building 602 and managed the factory where the explosion occurred. For these reasons, it appeared that the plaintiff was pursuing liability against AAC based on AAC's control of AES's building 602. As I mentioned, this theory would fail because this case would therefore belong in workers' compensation. However, frankly, we didn't think the amended complaint was pled sufficient enough to warrant even a motion to dismiss. So we asked for the more modest relief that is, my understanding, routinely granted in the state. Just asking the plaintiff's counsel to provide a more definite statement such that we can review and respond to it. However, like I said, just last week, in opposition to AES's motion to quash the third-party subpoena, the plaintiff's counsel clarified their theory, admitting that they were traveling only under a premises liability and, contradiction of their amended complaint, that AAC has no control over AES's production of building 602. For instance, on page 5 of that opposition, plaintiff's counsel states, quote, plaintiff has pleaded a viable Tennessee premises liability This clarifies their view. Then on page 14, they state, but plaintiff does not allege that AAC directed AES's industrial operations. Plaintiff alleges that AAC, as owner of the property on which an inherently dangerous activity was permitted, had knowledge of the dangerous conditions, making clear that this is now a premise liability claim, that AAC actually has no control. So although plaintiff's theory of liability has been clarified, the amended complaint, the operative pleading, remains too vague, too ambiguous, and not clear enough for us to frame a response. It's our opinion in the relief that we request. The complaint was conformed to plaintiff's counsel's new theory of the case. We ask that the court grant the motion for a more definite statement, order the plaintiff to sufficiently plead a premises liability. This relief is necessary here. This modest relief is necessary here because our client, AAC, needs to know under what theory it is has to be liable in this case to frame a response. It's also necessary, and we'll touch on this more with respect to the motion to quash, but it's also necessary a more completed and more sufficient pleadings is necessary so the parties in the court can know the scope of discovery such that we are able to analyze and put some parameters on what is discoverable in this case. Thank you.
Morning, Judge. My name is Taylor Pace. I'm here with Scott Armstrong. We're with Armstrong Lee Baker in Houston, and we're with Joe Griffith and Tanner Gibson at Hughes and Coleman. Before I kind of get into what's going on here, I think you asked the right question. You said workers' comp benefits from who? One of the big defenses that they're raising is that this court does not have subject matter, that this belongs in the workers' comp court. I think that, Judge, I think you hit the nail right on the head with that. And so by way of brief introduction, this is a real complex case. There's a lot going on. I'm going to simplify it just to a few bullet points right now. Because of multiple systemic failures at this factory, 16 people are dead. This is the largest TOSHA violation in history. People have died at this facility previously under very similar circumstances and explosions. And the president, CEO, manager, founder of the company have served time in federal prison for scamming the military and giving them weapons that were not up to snuff and not giving the military what he said he was giving the military. That's AES. That is not the defendant in this lawsuit. That's AES that ran the facility. But our defendant here is AAC. AAC is the premises owner, and AAC knew about all of these things. And we know they knew about all of these things because the owner of AAC is also the owner of AES. Exhibit 1 to their motion is the lease signed by John Sunday, the man who served time in federal prison for scamming the military, on behalf of AES, and it was also signed by John Sunday on behalf of AAC. And I believe that everything counsel just argued gives you everything you need to know that they understand what the allegations are of this lawsuit. They know what they need to be responding to. The motion for more definite statement should be denied. There's fair notice of what our allegations are. There's no question what our allegations are. What's going on here is that their client has essentially instructed them to not participate in litigation without a court order requiring them to do so. And I haven't met Mr. Griffin before, but Mr. Yancey, Mr. Blair, they've told me that on the phone. They told me I could tell you that at this hearing, that that's their instruction from their client to not participate without.
Let me make sure I'm understanding you. You're saying that defense counsel has told you directly that they're the owner, their ostensible ultimate client, Mr. Sunday has instructed them not to participate in any discovery in this case unless there's a court order.
They didn't say Mr. Sunday, but they did say their client. They weren't specific about who it was.
All right, go ahead.
And so that handles the motion for more definite statement. I want to get ahead of the subpoena issue because I think this is going to drive that point home when we talk about the subpoena. videos or photographs of the explosion, security camera footage from that day, documents pertaining to work being done that day.
I'm
Complaints.
sorry, are you now dealing with the motion to quash?
Yes, Judge, I apologize.
Sorry.
These are the things we're requesting our subpoena. Plainly discoverable. Simple. This is a softball subpoena. There's no way they're gonna object to these things, subpoena. And they've refused to confer. They've refused to produce anything. They've refused to work with us. We don't have a single document. And so we can go by it, go through this today in this hearing, line item by line item, figure out what they need to produce, what they don't, but I think they should have worked that out with us. We've spent hours on the phone to get nothing. And so all of that, and from the outset, they filed their motion to quash without conferring with us, which is against the local rules. We think the motion to quash should be stricken. The motion for more definite statement should be denied. And we're respectfully requesting an order. We shouldn't have to do this, that they're going to engage in discovery. So if you have any questions, I'm happy to answer them. That's from the outset, that's what I've got.
Your Honor, Mr. Pace and I and Mr. Yancey, who's on the meetings, have had a number of telephone conversations. During none of those conversations has my client, have we relayed, our clients have not instructed us to not participate. To the exact contrary, our clients have an entire team of lawyers who have been working around the clock tirelessly, gathering documents, reviewing documents, and producing documents to various government agencies I didn't even know existed. With respect to this case, the thrust of our motion for an evidence statement is that this case the court needs to satisfy itself that plaintiff has established the court's subject matter jurisdiction. Unless and until that happens, the court can't require AAC to respond to the court cannot issue an order enforcing the subpoena in the case in which it lacks subject matter jurisdiction. Now, Your Honor, we can get to the motion to quash here subsequently, but I want to highlight that during Mr. Pace's argument, he asked you to deny the motion for more definite statement because it's seemingly obvious what plaintiff's theory of the case is. I'm not totally sure that plaintiff's counsel knows what their theory of the case is. They plead one theory. Then they double down on that theory in opposition to our motion for more definite statement. Then in response to a motion from a different entity, AES, the motion to quash, they come up with a new theory. Your Honor, we need to know what plaintiff's counsel's theory of the case is. That will inform both whether this court has subject matter jurisdiction, which is a critical and threshold issue. It will also inform whether or not these documents they're requesting are within the scope of discovery. The scope of discovery must be tethered to plaintiff's claim. Plaintiff's claim currently is that AAC controlled, operated, and owned the building. That is not what their discovery requests go to. And moreover, with respect to their discovery requests, to the extent that their theory of the case, this is a premise liability case, AAC somehow knew what AES was doing. None of their discovery requests go towards any communications between AES and AAC. There is not one request that asks for documents saying, what did AAC know? What did they know about? And when did they know? They say that that Mr. Sunday signed the lease. That's not sufficient to pierce the corporate veil, and it's certainly not sufficient to prove that AAC knew or had constructed. But like I said, Your Honor, we'll get to the motion to quash next. But for purposes of the more definite statement, our arguments essentially remain unrebutted. That the case, they've brought a case, they've identified AAC, they've said something happened, AAC must be liable. We submit that's not enough.
Well, let me ask this question because the complaint, the amended complaint, makes certain allegations and tells you more or less what you're saying is that there was negligence involved. And then you're saying that in the discovery requests or in response to the motion to quash, that they're now saying that it was a premises liability. Is that
That's
correct?
exactly correct.
Right, but it doesn't change what they allege in the original complaint.
That's
In
exactly.
Tennessee is a notice pleading state, is it not?
Yes.
In which we are only required in pleadings to put the other person on notice of what it is, the nature of the claims, and give them a reasonable short statement of what that is. It doesn't require detailed pleading of every aspect of their claim. And if someone makes a claim that is not later supported by the evidence, then they don't amend their pleadings to include an alternative grounds for relief, then obviously it's subject to a motion for summary judgment. If in fact the proof at that stage is such that they can't sustain their allegation. What you're asking is for me to make them state that what they really want is what they're saying in their discovery, not what they've said in their amended complaint. Is that more or less it?
That is not it. As the complaint is currently pled, it appears that this case belongs to workers' compensation.
I understand what you're saying.
As plaintiff's theory of the case, they put forward in a brief to the court, were that in the complaint, it still likely would not survive because it lacks any kind of specificity as to who did what, when, where. Under Tennessee law, they must do more than identify tragedy and name a plaintiff. All we're asking for them to do is amend their complaint to provide us actual notice as to who did what, when, and how that is negligent. With respect to, in our briefing, we talked a great deal about duty and how AAC has a duty towards its tenants and employees. It's a very modest relief. It will not slow down the proceedings in this case. I think they have a couple of weeks, 15 days to provide an amended complaint. And then we can, we're amenable to a shortened cancer response timeline, and we can up to the races both with respect to litigation and with respect to the third parties.
All right. This is a very complex case. It's not the first time that I've dealt with the tragedies that occurred at this location. We had a prior case some years ago that more or less involved some of these same parties. I think they were under different corporate names at that time, but it was a similar type situation. And that litigation, I think, ultimately was resolved. In determining the rights of the parties, it's incumbent upon this court to try to make sure that both sides have an adequate opportunity to understand the evidence again that they're dealing with and what the other side is going to do under our rules of discovery. Under the rule for motion for more definite statement, which is rule 12.05, states if the pleadings of which a responsive pleading is permitted is so vague and ambiguous that a party cannot reasonably be required to frame a responsive pleading, the party may move for a more definite statement before interposing a responsive pleading. The motion shall point out the defects complained of and the details desired. If the motion is granted, then the order of the court is not obeyed within 15 days after the notice or within such other time as the court may file. The court may strike the pleading which the motion is directed and make such other orders deemed just. I think in this, because of the nature as was pointed out, if in fact the plaintiff was an employee of the defendant and as might be classified, then this case does not belong in this court. It belongs in the court of workers' compensation because by statute, all workers' compensation claims against an employer by an employee are required to be heard by the specific workers' compensation panel. For that reason, I think it is important to try to identify at this stage whether or not we have jurisdiction. So for that reason alone, I'm going to grant the motion for a more definite statement. I'm going to allow the plaintiff to have 30 days in which to make the responsive pleading. More definite statement, in other words. Now we move to the motion to quash.
Thank you, Your Honor. With respect to the motion to quash the subpoena, I think in light of the court's ruling, subject matter jurisdiction is in question, if not established. I would recommend that we wait and see what the amended complaint says that will determine the scope of discovery.
You understand, I've not required them to make an amended complaint. I've only required them to make a more definite statement, which are two different things. So they may make an amended complaint, but that's up to them. I'm just simply ordering that I've granted your motion. I would agree, but by the same token, this is a case that I think needs to be moved along, and it does not need to languish on the court's docket. And, you know, if the plaintiff, I want to hear from him, from them, as to whether or not they want to proceed with discovery while they're doing their amended complaint. And he's nodding in the affirmative, so I'm taking it from his nodding that he does want to proceed. So let's go ahead and deal with your motion report.
Okay. With respect to the timing here, plaintiff's counsel makes a lot of the statute of limitations expiring in October 10th, which is 5 months away. There's two things there that I think are important for purposes of this motion. The first is that AES, who is subject to the subpoena and who makes the motion to quash, and AAC, who they reference in their opposition brief, neither one of those entities, neither of my clients, are really concerned with the statute of limitations. We are not trying to run out the clock to say for our purposes. As your honor has noted, AES can't be sued because they were plaintiff's father's employer. AAC has already been sued. So neither of my clients have any interest in delaying this case for purposes of running out the statute of limitations. I think the second point that's important is plaintiff's counsel is, I think, misframing why this case has taken 6 or 7 months to get where we are today. The complaint was filed on October 16th, but it wasn't served. They amended their complaint a week later, but didn't serve it until November 14th, so a month ago. On January 22nd, we filed our motion for an evidence statement. We did so because we accepted service of the amended complaint. Plaintiff's counsel served the initial complaint. They served us with the wrong document, so we got 60 days to respond. Then in March, plaintiff's counsel served AES with a subpoena that is the subject of the motion. And at this point, Your Honor, the case has been pending for 5 months. We timely moved to quash the subpoena, and we worked with plaintiff's counsel to schedule the motion for a hearing. So they make a lot about the amount of time that has passed since they filed their complaint, but it has not been as a result of AAC or AES's delay or refusal to schedule this hearing. Your Honor, so there's not really a delay on the part of the defendant or AES. And frankly, Your Honor, there's really not a rush. We're not at the rush stage yet. Like I said, AES has been working tirelessly to collect its documents, review them, and then produce the requested documents from government agencies. Should the court determine that some of these subpoena requests documents are within the scope of discovery once we have their more definite statement, AES is more than capable of quickly reviewing documents in response to those requests. But like I said earlier, regardless of the timing issue, AES can only be ordered to produce documents that are within the scope of discovery. Before we can know what those documents are, we need to know what the scope of discovery is, which I think we'll have a much better idea once plaintiffs' defense counsel has provided a more definite statement. But without any idea of what the scope of discovery is, we just can't know whether their requests come within the scope of discovery. 26.02, as I noted, 26.02 requires the discovery be tethered to the plaintiff's claim. And we need to know exactly what their claim is before we can use responsive documents. Thank you.
me make sure I'm understanding. The subpoenas were not to AAC Investment LLC, the party to the action. One was to AES and the other was to Fikes Corporation.
That's correct.
Right, so I just wanted to make sure I was clear as to who was objecting. So.
Yes, I believe both objected. We can handle the AES for now. That's easier. Steve Snyder for Biker. So the first thing I want to point out, council just mentioned that AES is more than capable of quickly reviewing the documents and producing them whenever it needs to. And so there's an argument in the motions about this being unduly burdensome and us having to pay for production, something like that. I think we can pass that. I don't know if they're withdrawing that argument. When it comes to neither entity being concerned with this statute, here's kind of what's going on. This facility is still operating today. A lot of our subpoena items are targeted at third parties who are present at the site, at the location, on and around the time of the explosion. And these are entities that AES and AAC are still doing business with today. And so I think they do have an interest in running it out. I think that they've got business interests, and I think that they're doing a favor for the people they work with at the facility by stalling this. And so all of this goes to exactly everything I was saying. They know what the allegations are. They know what the lawsuit's about. They know what the scope of discovery is. It's fair notice pleading standard. They understand what we're alleging. It's just drawn out the clock. So, and happy to answer any questions. That's all I got.
You want to be heard on Fikes?
Yeah, sure. Good morning, Your Honor. Steve Snyder for Fike, who is a non-party and not related to AES or AAC. We were served a non-party subpoena by the plaintiff's counsel. We filed a motion to quash.
So explain to me what I understand what AAC and AES had to do with this explosion that took place. What is Fikes' position? What exactly was Fikes? And what is Fikes and what were you doing?
That's what it's part of what we're trying to figure out, Your Honor. Fike makes, I know Fike, for example, makes equipment for video equipment and cameras. And I think there's a concern that there might have been some Fike cameras in the location. And so I know Fike showed up in I want to say a chemical safety board memo that popped out in March. And then shortly thereafter, we got this subpoena. So I think our name appeared in the chemical safety board report. So that's where we came from. The subpoena that Fike was served was for documents, but the first part had 25 questions, interrogatory type questions that were submitted to Fike, which piqued my interest because that's not allowed under the rules of civil procedure. So that's what really spurred our motion to quash those questions. Plaintiff's response, it appears that they had withdrawn those questions. So I believe those are withdrawn. That's not going to be an issue. The subpoena also requested insurance documentation, questions regarding insurance. That's not appropriate either under Tennessee law, Thomas v. Oldfield, or the Tennessee rules of civil procedure. I believe in the amended response, those requests have been withdrawn. So those are off the table. That leaves us with about 24 document requests. Fike is a non-party. Plaintiffs must make sure, pursuant to the rule, they must make sure that they take reasonable efforts not to cause a non-party undue burden or undue expense. Undue burden, when you're looking at that, it's going to be proportionality, time and scope, and breadth. And when we're looking at the requests, the issue that's come about is to provide any and all, for example, maintenance records with respect to any maintenance performed at the AES facility. I don't know what that means. Any and all repair requests. I don't know what that means. The span is 11 years. And so what I've instructed my client to do, and what we have done, and I will present to the court, that Fike and Plaintiffs' counsel have engaged in continuous communication regarding this issue. I sent this subpoena to my client and like, go get me everything you can get me. And they're gathering documents right now. And I have a firm belief that once the documents get back to me in a format that I can assemble them, that I can have a meaningful conversation with plaintiff's counsel and that we can reduce and narrow the scope of the request to where they're happy and we produce the documents, keep the court happy as well. Also, plaintiff's counsel in the response, we talked about protective order. They brought that up. I think we can get a protective order as well because there's some proprietary information that, again, it's not super top secret stuff, but there is proprietary information that we just don't want distributed. Also, there's requests for like system architectures, and videos, and things of that nature. I'll need to get with plaintiff's counsel to kind of figure out exactly what they're looking for. Like I said, we've been going on negotiations, not negotiations, but communications regarding the request. And frankly, Your Honor, I just kind of ran out of time. We did not want to delay. So I knew that this motion was set for this morning. So with agreement of counsel, we kind of piggybacked onto it. So we get this before the court. But again, I believe that we can start producing documents and probably start producing them pretty quickly. Probably within the next, I believe I can probably get documents to plaintiff's counsel within the next 30 days. They can look at them. If they have objections or they want more things, I can produce them. I can do a privilege on things that they requested. I don't have a problem doing that.
All right.
Judge, real briefly on the FIDE subpoena, if I may. So what I'm hearing is that they're generally agreeable to producing documents related to this explosion.
That's what I hear.
And so what I'll be asking judges in order that they produce the documents that they believe are responsive to the subpoena, subject to objection. I'd ask it be done in the next 2 weeks. I think we could live a little bit more. This has been pending for quite a while. And I would like to at least start seeing where we are with the documents.
He said 30 days. You're saying 2 weeks.
If I may address that, Your Honor. So again, I need to get documents assembled. I need to send them back, make sure that I'm not missing anything, and I get the plaintiff's counsel. I can't do that in 2 weeks. I do need 30 days.
I'm going to give him 30 days.
I understand, Judge. And in that regard, after that's done, if there's any issues we need to bring to you, because we're ruling at that point, that's when I'd say we do it. Otherwise, we can.
Well, both of these motions to quash, it seems to me that preliminarily I'm going to rule deny the motions to quash, but allow the parties to negotiate the exchange of the information and give them 60 days to try to resolve that. If there is an ongoing issue regarding that, then you can contact me and I will arrange a hearing. It may be out of this county. It may have to be in another county because I'm here for a month term of court, and then I move to the next county, which where am I going? In July, I'll be in Cheatham County. So, so I think that the simplest thing would be just preliminarily deny the motions to quash, but reserve both of the defendants or all the parties who have moved to quash, reserve the right to re-argue or to reassert their motion to quash. So I'm denying it without prejudice, but allowing the exchange of information to take place over the next 60 days, and then we'll go from there.
And so I understand your ruling, Judge. Are you saying that the non-parties shall respond to subpoenas within 30 days and then we work out disagreements within the remaining 30 days?
That's my point.
I understand. Thank you, Judge. I'm not further.
So if we're clear on the motions to quash, I think it is important to try to get as much relevant information. The rules of discovery allow for all you to discover any information that's relevant or might lead to relevant information. So they're extremely broad, but there is a standard by which you can become burdensome and overly expensive, especially to non-parties. So for that reason, I'm going to give you 60 days to try to resolve these issues about the subpoenas and expect that they be complied with. If there is an objection made to the broad scope of that, then we'll deal with it down the road. So I want to give plaintiff the 30 days for their filing of their motion for bill of particulars of it, and then hopefully give some time after that for this exchange of information.
I understand. Thank you, Judge.
Anything else? For some reason I didn't think it was going to be that simple.
Just one thing. So we appreciate Your Honor's ruling of 60 days, 30 days to.
I don't know that you really appreciate
Well,
it.
I understand it. What I would ask for is a slight modification for AES. Their more definite statement will be filed in the next 30 days. At that point, we have 30 days to produce documents, and then an additional 30 days to negotiate. So our AES is 60-day clock.
You have any problem with that?
Judge, my only issue would be that I think that the idea of the more definite statement is coming down to this whole idea, is this a premises case or not? Well, it certainly is, it's a premises case. Our pleadings are that they had control over the facility, and they're attempting to say that we're saying that they had control over the
The
people.
motion for a more definite statement is not the same as the amended complaint. That's the way I read the rules of civil procedure. And for that reason, even though I've ordered you to give a more definite statement, it's just like in a criminal case. A more definite statement can be required to supplement what the indictment says itself, but it doesn't change the nature of the offenses. You have set forth in your amended complaint your basis for recovery. This more definite statement is an explanation of facts that you believe support your theory of recovery and give them notice of what your intentions are. It is not an amendment to the amended complaint. And for that reason, what you're asking is that once you have 30, let them have 30 days to file their their bill of particulars. And then from that point, you want 30 days to comply.
That's correct. And the reason for that is I think the more definite statement will give everyone a better idea of what their claim is, which will give us a better idea of the scope of discovery. And until we know the scope, a lot of their discovery requests appear to be fishing expeditions in search of other entities to sue, which is not AES's duty to provide, and it's not come with the discoveries.
Because I believe that all of the documents that are contained in our subpoena to AES are discoverable under theories that have been pled under the existing amended complaint.
Well, I'm not going to, again, AES is not a party to this action. So they're a non-party, and under the rules, basically, the rule 45.08 basically states that a person responding to a subpoena need not provide discovery of electronic. So on a motion to compel discovery or to quash, the person from whom the discovery is sought must show that the information sought is not reasonably accessible because of undue burden or cost. If that showing is made, the court may, and it goes on to talk about other things that I can do to specify conditions for discovery, including the allocation of cost. It is, the plaintiff is arguing that their basis for the recovery is sufficiently set forth in the amended complaint. Your argument is essentially saying, yeah, but I don't agree with that being the basis of their recovery, and therefore I would like to have them file this motion, this bill of particulars, so I can find out if my theory is right, that they don't really have, that this court doesn't have jurisdiction. But I think in order to allow the plaintiff to properly file its motion for this, its bill of particulars, that it doesn't seem unduly burdensome on the defendant to produce the documents under the subpoena prior to the expiration of 60 days. So I understand what you're saying is essentially you would like to have your 60 days start to run after their 30 days. And I'm not going to agree to that. I'm just going to order that they have 60 days to respond. So you have 30 days for your bill of particulars. They have 60 days to respond to the discovery and any other issues. If you find that the motion for bill of particulars, I don't know why I keep saying that. If the bill of particulars sets out something that you think, this is exactly what I'm saying, and now I have proof, then you can renew your motion to quash. That's what I've said, and I will give you a date to hear that, even if it's all by Zoom. Y'all have Zoom in Texas?
We do, Judge. Although I prefer in person, but I'm happy to do by Zoom.
Thank you.
Well, I'm going to tell you that I went to law school. I'm born and bred Southerner, and I grew up in Houston County, from over here in Tennessee, but I ended up in law school in Houston. Long story. And all my friends down there made fun of me, but the year I took the Texas Bar Association, the highest score on the bar on the bar exam was made by Paul Sexton, who was one of my classmates at the University of Houston. He was a chemical engineer, graduate of Vanderbilt University from Nashville, Tennessee. So they had us all gathered there in Austin, Texas for the swearing in. And I know you don't really want to hear all of this, but anyway, he was asked to speak. You know, he got to speak to the assembled group, and they had the Court of Criminal Appeals, the Court of Civil Appeals, and the Supreme Court of Texas up there. Chief Justice of the Supreme Court was introducing him and said, now, our highest score on the bar exam was Paul Sexton. He's from Nashville, Tennessee. He says, but don't worry, I've checked, and he's wearing shoes today. Why are y'all laughing? Because that's exactly the response that all of those people in Texas had. So when I got back up here, I was doing research on a case involving jurisdiction. In the Texas, it was a divorce case, custody case, and the Tennessee courts had asserted jurisdiction over the custody disputes. Texas had as well. Texas Court of Civil Appeals had said that they had jurisdiction. Justice Joe Henry was writing, he was long since deceased, but he was writing his opinion and set out all the reasons why Tennessee had jurisdiction. And at the end, he said, as for our esteemed brethren on the Texas Court of Civil Appeals, I would remind them that if it were not for the state of Tennessee, Texas would still be a Mexican province. So I photocopied that. I made a copy of that, and I sent it to every one of my friends in law school who had laughed at that and highlighted it. But anyway, I still have my Texas law license. It's rendered inactive, but I went through hill and high water to get it, and I wasn't going to give it up, even though I'm back here. So, anything else before we adjourn?
Nothing for the plan, John.
Thank you. I appreciate it. We're going to stop doing our circuit civil docket call. The next thing I have is our Chancery docket.
Yes, sir.
Thank you. Thank you.
John Williams.
Nice, Steve.
Nice to meet you. I'm Eve Stanford. I'm the circuit court clerk.
We've shared some emails. so
Okay,
it's nice to put a
good. It's
name to
nice
this.
to meet you.
You too.
And you have a safe trip heading home.
Yeah, hopefully not too wet.
I hope not.
Yeah, that is week.
No, we actually had a jury trial. It was supposed to take 2 days, but I've already heard that that's not going to go. So I should only have juvenile court tomorrow and general sessions Thursday, and no added jury trial on top of that. I'll take my normal.
More blessings.
Absolutely.
Have a good week.
Have a great day, honey.
Yeah.
Yes, sir.
I was just sitting there and thinking about all those lawyers. I could hear the cash register, ting, ting, ting.
Ooh,
I'm telling you what,
it's a whole lot of blue suits.
a lot of time.
Whole lot of blue suits over there.
So works differently. Stand. Sure.
Yes, he'll just, so here, can't. Put her under oath. She's staying right there, just ask her a question.
Okay, okay. So we do the formal question. And Davis can do that state repetition. You just say, yeah, I got a copy of that.
Bring that. Me and his son.
What is his name? Trent?
Yep.
Yeah, I had some. And I live in the same neighborhood I was out exercising. That's where I go.
Haven't you get coming in this morning?
No, I didn't. I didn't get caught in it. Luckily, did
Lucky
you?
you.
Did you?
No bed. I had an umbrella.
Yeah, I had an umbrella too, just in case. So. Looks like you might get it on the way back too. Walking back over there.
All right, the Humphreys County Chancery Court is now in session. The Honorable Judge David Wolf, present presiding. All who have business draw near and be heard. God bless the state of the United States and this honorable court. May be seated.
Hi, good morning. We're going to start the circuit docket, the Chancery docket. My microphone is dead. We'll try again. Call the first case.
2026 PR 21 regarding William Albert by Billy Dean Albert.
Good morning, Your Honor. Chris Johnson
morning.
with the petitioner, Billy Dean Albert. We have before you a petition to admit the last will and testament, or a copy of the last will and testament of William Thomas Albert for the purposes of establishing muniment of title. Billy Dean Albert is prepared to give testimony that she had the original will after his passing, that it was lost sometime after his passing, that the copy we have provided to the court is an exact replica of the will, and that all it is doing is getting these two parcels of property to the decedent's son.
All right. Ms. Albert, if you'll raise your right hand, let's place you under oath. You solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right. Go ahead, Mr. Johnson.
Thank you, Your Honor. Miss Albert, the will that we have provided to the court, is that the will of your late husband?
It is the will of my late husband.
Do you know of any reason where he would have possibly revoked it or destroyed it?
No,
In fact, did you have in your hand the original copy, the original will after he passed away?
I did.
And what happened subsequent to that will, or to that him passing?
I brought the will with me. You made a copy. I went ahead and I put it somewhere, but I don't remember where I put it. And I've looked everywhere for it.
And that's my next question. You've made a good faith due diligence search
Yes.
of all your papers and places.
Yes,
And it obviously difficult frame of mind after your husband passed away.
yes,
But the copy, you've seen the copy that we provided to the court, and that's an exact copy
Yes.
of the will. And in doing this muniment, all this is doing is getting property to your late husband's son, correct?
correct.
Does that suffice for the court, Your Honor?
Does, Ms. Albert, I would have to say I've had exactly that same experience with some things that I put them where I thought I'd know them. exactly where they were, and I go back to find them, and I can't find them anywhere, so.
I thought I
will
did
admit-
too.
We will admit the will for purposes of monument of title.
Thank you, Your Honor.
If you'll submit an order, please.
We will, Your
I
Honor.
think you are.
Thank you.
All right, I'll see the order now, Mr. Johnson, in the file, and I'll sign it.
Thank you, Your Honor.
Thank you.
Welcome. All right,
And we'll mail the petition.
Oh, okay, that's fine.
2026 PR 23 regarding the estate of Morocco, Thomas Bacca.
Good morning, Your Honor.
Good morning.
Randy Miles of the National Bar.
All right.
You're not used to seeing me here, I'm sure, once in a while in Dickson.
Not down here, so.
Dixon County occasionally, but I have with me this morning Martha, who's the petitioner, and her mother passed away November
Sorry for your
24th.
loss. Let's go ahead and have her placed under oath. If you'll raise your right hand, please.
Do you solemnly swear or affirm that the testimony you shall not give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Would you state your name?
Martha Jane.
And Ms. Day, you're the daughter of Morocco Hamasaka Day.
Correct.
And she passed away on November 24th of last year, 2025.
Correct.
Did she have a will?
She did not, to my knowledge.
And was there a search made for a will? And you were unable to locate
That
one?
is correct.
Now, you're the petitioner in this case, but you're not seeking to be made the administrator of the state.
I am not.
And you have two sisters.
Yes.
And those are Patricia and Ann, is that correct?
That's correct.
And they've been given notice of this hearing.
They have, as we all were.
Yeah, Your Honor, there's a letter, I think, that's in the file. There was the other two daughters had some unspecified desire to address the court. I spoke with Mr. Daniel about it, and we didn't see any need to postpone. Well, I'll just ask my witness. There's been some disagreements among you and your sisters over the years.
Yes, that's correct.
And is that why you asked to have an independent administrator appointed?
Yes, I believe it would be best in the interest of all parties and fairness.
And I'm assuming that each of you would object to any of the other ones being named administrator.
Absolutely.
So, and so we got in touch with Mr. Daniel and he agreed. Is that your understanding?
Yes.
You actually are a resident of Kentucky.
Yes.
So it would be more convenient for him being a resident of this county.
Yes.
And at the time of her death, your mother was domiciled in Humphreys County, with an address of 102 Hickory Lane in Waverly.
That's correct.
Is there anything else I need to ask my witness?
I believe so. At this point, we're just seeking to have an independent administrator ad litem appointed. Is that correct? And Mr. Daniel is, go ahead.
Well, I forgot to ask her about the value of the estate.
All right.
And so the main value of the estate is in the house.
Yes.
And we just looked it up. It's about 360,000.
About 365,000.
Right. There is some personal property in the house.
Yes.
And do we have any idea what the value of that is?
No.
You also said there's a hoarding situation there.
Yes.
So that's going to have to be sorted out.
Yes.
All right. Is there anyone else here who wants to be heard on this?
Yes, Your Honor, I believe my client here would like me to be appointed as administrator in lieu of Mr.
All right. Let's, Mr. Miles, if you'll step aside, let me hear from the other party and then I'll make a decision. Good morning.
We have been retained by Ms. People here.
What is your name?
Rebecca Lupton.
Okay. And where are you located?
I'm in Clarksville.
In Clark. All right. And you've been retained by one of the sisters or daughters, rather, correct?
Yes.
I interrupted you. Go ahead.
You didn't interrupt, Your Honor. We have been retained by her because she wishes for me to serve as administrator.
And she's wanting you to serve as administrator? Well, and I respect that request, but the fact of the matter is, it does seem to me that there needs to be, because of the animosity between the siblings, that there needs to be an independent person serving as that. And because you represent and have been retained by one of the sisters, Mr. Scott Daniel, who is a local attorney, is not affiliated with any of the parties involved. He's not been retained by any of the parties. He is an independent person, and this court has confidence that he will do a good job of serving as administrator ad litem. And of course, you and your client will be able to communicate with him and obtain copies of all of the information that he has. So I'm going to grant the request to appoint Mr. Scott Daniel as the administrator ad litem. All right, thank you.
If I could approach, I did prepare a proposed order. And what I did with that, I left a blank in there for anticipating whatever Your Honor may wish to do in terms of the bond. And I thought what I would do if Your Honor entered that order today, then I could get the clerk to make copies, then I could serve those on other two sisters.
Normally, with an attorney serving as the representative of the estate, I would waive the bond. Does either party have any objection to Mr. Daniel serving without the requirement of the bond on his oath as an attorney? So that'll be part of the order. All right, I'm going to order that the bond is waived. That way it'll be an expense to the estate that we can avoid.
I didn't want to make any presumptions, Your Honor.
But he'll be filing an inventory within 60 days, and annual reports will be on, I guess it would be today's date is the first, and the second day of June 2027. All right, sign the order.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
2026 CV 53 Teresa Lott versus Christopher Lott.
Microphone with the stand on doesn't seem to be. Okay. Just excellent.
Keep your hands out of your pockets, please.
All right, this is a hearing on an order of protection for the extension of temporary order. You are Teresa Lotz, is that correct?
Yes, Your Honor.
Both of you raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm that the testimony you shall not give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Fine. Thank you. Step to the one side, please. Ms. Lotz, if you'll come to the podium. You sought and obtained a temporary order of protection in this case, and this hearing today is to determine whether or not there is cause to extend that order of protection for up to 1 year. It is your petition and your request to obtain an order, so I must first ask you, do you still desire to have an order of protection?
Yes, Your Honor.
Mr. Lotz, this is, again, as you heard me say, a hearing today to determine whether or not an order of protection should be extended, and for that reason, you have the right to simply either agree to the extension of the order of protection or to waive the order of protection, or to contest the extension of the order of protection. Do you wish to contest the extension of the order of protection?
Yes, Your Honor.
All right, have a seat at the table. Ms. Lutz, if you will come around to the witness stand, I'm going to ask you to have a seat. First of all, you've been placed under oath, so I will remind you, you are under oath. This is your hearing today for you to tell me why you feel that there's a need for an order of protection. And even though there's one been issued, I did not issue that order of protection, I don't think. So you need to start from the beginning and tell me every reason why you feel that there needs to be an order of protection, and you need to speak directly into the microphone.
Yes, Your Honor. We were divorced in 2024, May of 2024. We do share a daughter together. Since being divorced, it has been countless times that he has been disrespectful, harassed, left voicemails that were threatening, and I just don't feel safe. He is currently living on the other side of New Johnsonville from where I am. And he has no business on my road. There's no businesses there. There's no reason for him to be there. It's not a way for him to get to work. And he has been on video driving past our home. With his history of domestic violence against me in 2021, I don't feel safe. He's made threats against myself and my fiance. So I'm not sure what I'm supposed to do. I was told by Officer Bailey in New Johnsonville that this is probably my best bet to get like the harassment and such to stop.
All right, in your affidavit of your petition for an order of protection, you state that he has made threatening statements towards you that cause you to fear for your safety, and that he has been arrested in the past for domestic violence. Was the arrest for domestic violence against you?
Yes,
And when did that occur?
in 21.
All right, and what happened to that case?
So we resided in Waverly, and we were at our home, and he followed me and the children outside with a loaded shotgun.
Okay.
And we ran to the neighbor's house and took
When he
shelter
had the
there.
loaded shotgun, did he threaten you with the gun?
Yes.
Okay. What did he say at that point?
Well, I can't recall exactly what his exact words were, but he did come out of the house, and the shotgun was fully loaded, and he racked it on the deck.
He racked it?
Yes.
Okay. Then you said that he had left you a threatening voicemail. What, on April the 19th? What did he say in the voicemail?
Well, the voicemail was not left on April 19th.
Okay.
That was when our last altercation was, when we were exchanging our daughter. But the voicemail stated that I needed to answer the phone and he was going to come get my hands.
And you took that as a threat against you?
Yes, sir.
And then you said he threatened you and your boyfriend on April the 19th during the exchange of your daughter?
Yes, sir.
Tell me about that.
So we meet in New Johnsonville at the Dollar General because I don't feel safe or comfortable with him coming to our home. So we met there, and just as he was pulling in, my fiance and I were sitting in separate vehicles because my fiance was coming through town and saw me waiting to pick Millie up. So he pulled into the parking lot as well. And as soon as Christopher pulled into the parking lot, he jumped out of his truck and started shouting at myself and my fiance, which caused our daughter to scream and cry. And I mean, I have a video of it. But he threatened my boyfriend, and he flicked his cigarette at my feet and said he was going to get me. So those are the kind of things that I can't tolerate anymore.
How often, you two are operating under a parenting plan that was granted in your divorce?
Yes, sir.
How often does he see the child or children that you have one child together?
We have one child together.
So how often does he have visitation with that child?
He's supposed to have every other weekend with her, and then even in odd years of holidays, it's just like a basic.
Okay. And has he been exercising that visitation?
I have been, since April 19th, I have kept Millie from him because I don't feel safe with the exchange. I don't feel safe with her being there. He's an alcoholic. And there's been times where he hasn't had food to feed her and stuff. So I didn't feel safe with her being there.
Well, you understand this order of protection is designed to protect you from domestic violence.
Yeah.
It is not intended to supersede or set aside a parenting plan that's issued in your divorce case, and you will have to go into that divorce case to alter or amend any sort of parenting time that he might have.
Yes, Your Honor.
So if in fact you were to have continue to let him have the visitation with your daughter, is there some other arrangement that can be made for the exchange of the
Yes,
child?
absolutely.
What would that be?
I would either ask my mother to meet him. That's really my only other option. I'm a transplant here from Chicago. We don't have any other family except
But your
for
mother
here.
lives here?
She lives here in Waverly, yes, sir.
How does she and your ex-husband get along?
I would say it's, fine. I wouldn't say there's any animosity there.
Right. Anything else you want to tell me about the situation? You and your allegations say that he's driven past your home and that he has verbally told you he wishes death on you.
Yes.
Okay. Can you tell me when that was?
I can't remember the exact date of when that was, but like I said, it's over the course of the last 2 years, and this is where we're at because of it. It's just compiled and compiled and compiled. And I just...
All right, Mr. Lotz, you're representing yourself, and as a result of that, you have the right to ask questions. It is not a point for you to argue with her, but rather for you to ask them in a question form. If you want to do that, you need to come to the podium, and we'll let you ask whatever questions you want.
In 2021, what was the verdict on all charges that were placed against me?
It was an 11/29, so as long as you didn't get in trouble, then I believe
the final sentence was all charges were dropped, correct?
It doesn't excuse the fact that it happened.
So was it continued for 11 months, 29 days? If there were no further problems, it would be dismissed. That's typically what would happen. Right.
There's also a written statement on file of what she has said, and that does not correlate with what she's saying today. April 19th of this year, your fiance used your phone to slander me. It was 2 days prior when I was picking up our daughter. And then
now you need to be asking questions. You're making statements, so you can only ask questions. I'm going to give you a chance. I'm going to give you a chance to testify, but right now you get to ask a question in a question form.
Did your fiance use your phone to text me the Friday before April 19th?
Yes.
Did he block me with your phone again?
Yes, because of what you were saying.
Have you read the parenting plan?
Yes.
When it comes to, do you have a physical copy of it?
I have a digital copy, yes.
Okay. Do you understand that we have to keep open lines of communication open?
Email is an open line of communication.
Then I'm not, no, that's for a later court date.
Anything else you want to ask in form of a question?
By verbal death threat, do you mean when I said I'm not going to have to deal with you much longer because of your family health history?
No.
I've got no further questions for her.
All right, thank you. You can step down.
Thank you.
Do you have any other witnesses you wish to call?
No, sir.
All right. Ms. Lotz has rested her case. Mr. Lotz, do you wish to ask any questions? Do you want to testify?
Yes, sir.
All right, come on up. You have previously been sworn, so have a seat, and I'll be glad to hear whatever you have to say.
Your Honor, I feel like this is nothing more than a manipulation tactic and parental alienation. The only time in our 12 years together and now almost 3 years divorced has been any physical domestic abuse. Teresa Louts was the aggressor. You can go back and look at the sworn statement that was made by her about the problem that we had in 2021. And the 15th and the 22nd, I had Officer Simpson on the 15th, and then I can't remember the other officer's name, come to my house and talk to her. She said that we weren't dealing with the parenting plan just by the book, by the letter, and that we would go back and forth. And that was the weekend after Mother's Day, the 15th. The 22nd, the officers went to the wrong house. They went and knocked on the door. And so the only reason I drove past the house was to get the address to call the officer back. Because I haven't had her address since she moved there. And I just feel like I'm getting parental alienation.
When you say parental alienation, is that because of the fact that you've not been allowed to see your daughter?
Yes, and it's not the first time. This past few weekends is not the first time.
She says that she makes the allegation that you're an alcoholic and that she's fearful for your daughter's safety. How old is your child?
8.
All right. And do you drink alcohol?
I do, but I actually recently quit, but I've not drank in front of my daughter it was 2023. It was it was during the very beginning of the divorce, and I was at a friend's house. But no, my daughter has not seen me inebriated since I left the house before the separation in September of 23.
So what is the problem between you and her right now? How would you characterize what's going on between you and her? She says you threatened her. Is that true?
To my recollection, no, I've not ever said anything physically threatening or directly threatening. I may have said things that were nasty about me just waiting for her to follow her family health history due to family or lifestyle. And
what do you mean by that?
Everyone in her family passes away before 65 or 70. And then I wouldn't have to deal with her much any longer.
All right. Anything else that you want to tell me about this situation?
No, Your Honor, I just want to see my kid. I don't care if I never set eyes on her again.
Good.
I don't want to be in the same room with her.
Ms. Lotz, do you have questions you want to ask him? This is your opportunity to ask questions. All right, then thank you. Step down. Based on the testimony, the court finds that there is cause for the extension of the order of protection, but only for a limited period of time. And that, as I pointed out, this order of protection is not going to suspend or supersede the right he has to see his daughter under the parenting plan. That remains in full force and effect. And therefore, the only modification I will make is that the exchange of the child will continue to take place where you've been exchanging it, but that the maternal grandmother will provide transportation for Mr. Lotz to meet his the grandmother of the child to get the child so that you don't have to have interaction. And by extending the order of protection for a period of 90 days, that's 3 months, that gives you all a cooling off period so that there's none of the situation. If you're going to file something in a domestic relations court to try to modify the parenting plan or to do anything else, then you need to do so. The only modification I would make at this point is that even though I take what you say at face value, that neither party will consume alcohol while this child is present. That means you as well as Mr. Lotz. And that just means you can drink all you want to when the child's not there, but don't drink when the child is there. You understand? Both of you? All right. Then I'll fill out that order and you can have a seat outside and we'll pick it up, okay?
Is there any way in the order you can put that I can, because we don't have an actual set date in our parenting plan for the every other weekend. In the order, can you put that next weekend is my weekend so that I have a basis on if I have problems?
Makes sense to me to go ahead and start. He hasn't seen the child for a while. We'll start it this weekend, this Friday, which will be the June the 6th, 5th, June 5th. June 5th, 6 o'clock. It's Sunday at 6 o'clock.
What happens if he doesn't bring her back on time?
He'll be in contempt of court and he'll be guilty of the criminal offense of a parental interference. So you understand? You take the child according to this order, and if you don't bring it back, then they're going to be right back in here to me and I'll issue a warrant for your arrest. I don't want to do that. I want you to both calm down and remember that your daughter is 8 years old. What's going on between the two of you right now, the anger that's going on is making an imprint on her. You're basically giving her the memory of how my mom and dad are acting when I'm 8 years old. Now, you think back, I can remember when I was 8 years old and what was going on. And those memories are not going to be pleasant for her unless the two of you can just say, you know, I'm done. If she has a boyfriend that doesn't like you, so be it. You know, you don't have to put up with it. You don't have to listen to anything he says. And if he's smart, he needs to keep out of the situation. I'm just telling you, you just listen right now.
Yes, sir.
And he needs to stay out of the situation that the two of you have. But frankly, I see no reason that the two of you can't raise this child together and just get past whatever the animosity is. Threats of any kind, even just making statements about her family history that she interprets as a threat, are not doing your daughter any good. So put your daughter's best interest first and be nice to her mother, and you be nice to him.
Yes, sir.
And if the two of you can do that, your daughter has a chance to grow up as well adjusted as possible. Otherwise, you're going to basically ruin every event in your daughter's life, every birthday, every holiday, every major event such as graduation. You're going to ruin all of that because she's going to know the two of you hate each other so much you can't even be in the same room. So think about that when you're dealing with the other side. You don't have to see her. You don't have to deal with each other in writing by text messages or whatever you need to do. He is not prohibited under this order from communicating with you by a text message, but a threatening text message, a hostile or accusatory threat text message would violate the order I'm putting down. Okay. All right. Just have a seat outside, and one of you can go outside, the other can remain in the courtroom, and I'll issue that order.
Then we're doing court on Friday for child support. Is that, will there be a way that we can be separated?
You can be separated at that point. Yes, while you're here in court, the bailiffs will assist you with that. Yeah.
Since I'm going to have no contact order with her, will I just contact her mother?
Yes. You want to take this over to? Kendra Michaela Killebrew versus Philip Alexander Killebrew. You'll come up, please. This is Mr. Killebrew. Mr. Killebrew, if you'll come take the opposite side of the courtroom, please.
Come right here, sir.
This is a hearing on an extension of an order of protection. You heard me just go through that procedure, so I'll explain it again. There was a temporary order of protection that was issued in this case and served on the defendant on May the 26th of 2026. This hearing is designed to determine whether or not there should be an extension of that order of protection. Ms. Killebrew, you are the petitioner. Are you asking to extend that order of protection?
I have an attorney and he's not present today and he asked if this be rescheduled so that he may be present to represent me.
Who is your attorney?
Olin Baker.
Olin Baker?
Yes.
And did Mr. Baker give an indication when he might be able to be here?
He did not. He just said that he was in court and he was afraid he wasn't going to be able to make it before this was over and he had told in the email. He said, he asked that I have it rescheduled.
Mr. Killebrew, are you planning to hire a lawyer to represent you? Then I assume you would rather have a hearing when the lawyer can be present as well. I can give you June the 5th, this Friday. The next day after that would be the 22nd. Do we still have the 22nd?
It's getting full.
All
The
right.
22nd may be better so he has room in his.
Oh, the 29th,
29th.
June 29th. All right. June 29th. We'll reset it for that time. Then the ex parte order of protection is going to extend until that time. So make sure that you're here on that day with your lawyer. All right, you're free to go until then. All right. Well, that concludes our docket for today. And tomorrow we said this case is off. Right? So, all right, then we stand adjourned.
All rise.
Does he need to give me paperwork before I leave?
Yeah, we're, if you just want to wait on the hallway, they're taking care of it, they're processing it right now.
All right, thank you.
Sure.